So I think we probably should get started. This isn't, my name is Avner Levin, just by way of my background. I teach here at Ryerson University. We have a little research institute, privacy and cybercrime. And my background is really legal. My education is legal, and my interest in these is more of a policy interest, and I don't claim to know half of the things that I learned this morning from Ian's excellent presentation on the technology and how it works. But so I'll be coming at it a little bit more in terms of general, I guess, policy concerns and questions that I might have when I'm thinking about it. And I think it might be some kind of Freudian slip. I didn't put drones for bad, I put drones are bad. So that's sort of where my thoughts are going. So I am playing a little bit of a devil's advocate just for the sake of the conversation. But I think it's important in a symposium like this to really be able to sort of put forward a strong position for and against, and then have it out and see where the balance may lie. So recognizing fully that I'm just standing between you and lunch, and Canadians have to have their lunch at noon, and we're already, I think, 40 minutes past noon. That's bad. So now let's see if this thing can work. Okay, so I'm going to talk about a couple of things, the privacy perspective that I want to bring to this, and can there be a balance, and really, again, from a legal and policy standpoint, and then hopefully we can get more into the conversation during lunch and over lunch. So I want to talk a little bit about something that privacy scholars call the mosaic theory. And the mosaic theory is something that is American. It's something that was created by the United States Supreme Court in a recent, and they didn't call it the mosaic theory, but the privacy scholars that jumped all over it did, in a case from 2012 that's called the United States versus Jones. That was a case in which the police placed a GPS device on a vehicle without a warrant. And the vehicle was traveling throughout wherever the locations were in the United States. But as far as the basic sort of popular perception is, the vehicle was in public spaces all the time. And so the question arose, and was this a violation of the American Fourth Amendment, because that's their sort of constitutional protection, and I'll read it out to you. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, and particularly describing the place to be searched and the person or things to be seized. So their amendment, and we'll talk a little bit more about the Canadian protection, which is different, as Andrew had said, but their amendment seems quite narrowly tailored and understood and based on this kind of conception that you've got like a physical sphere of privacy, and then the government might want to come and invade that physical sphere of privacy, and that amendment is giving you the protection or the rules under which the government can do it. And of course, the judicial supervision is a key element of all of that, and the requirement for a warrant. But that is a physical sphere, and then if you're outside of that physical sphere, if you're in a vehicle traveling outside in public space where people can look at you, then it's not clear. Now, the further problem is that the traditional Fourth Amendment cases that happen are discrete in the sense that they are one event things. So you want to wiretap a phone, or you want to go into somebody's house. Those are sort of discrete one-time events that the police wants to take action on. And if you think about the Jones vehicle in the discrete specific terms, and you isolate it and say, you know, the vehicle is right here at Yonge and Dundas, and then the vehicle is up at, you know, Avenue Road and Lawrence, you don't really see that there is perhaps an issue that brings forward Fourth Amendment concerns or privacy concerns. When you talk about the continuum of what has been happening with this vehicle over a large period of time, that sort of bugs the privacy scholars and the general public. They feel that something is wrong. They feel that there's some kind of right that perhaps is being violated, but they're not sure, if the Fourth Amendment language perfectly captures that, that kind of right. If I could call what they're concerned about, I would probably say it's their liberty that they're concerned about. It's some kind of a sense in which Americans feel that they have a freedom from government. That is, of course, another part of their constitutional life, liberty, and the pursuit of happiness, and that's very significant for them. And it's interesting, if you're a privacy scholar, you know that people use the label privacy as a label to capture more fundamental values. And the Americans often talk about privacy, and what they're really concerned about is their liberty, their freedom from government. And the Europeans, if I can grossly, overgeneralize, often talk about privacy and think about their dignity, their reputation, their image in the eyes of others. And it's, of course, a very sort of gross generalization, but it is something that's useful to help and understand as a tool, as the way the word privacy is being used in these conversations. And if you see this recent NSA scandal, you can see the impact that it had was because it involved, for Americans, the government. And if we talk about later on drones today, we'll see that that's a big part of the conversation as well. So what this mosaic theory does for the scholars is really, it tries to protect the notion of privacy as liberty, as freedom for government. And the theoretical tool that it uses to achieve that is by shifting the focus away from one specific incident, one specific stone, and saying, well, there's a whole picture here, there's a whole mosaic that's created by these sort of individually discrete, separate incidents or surveillance that perhaps in of themselves may not trigger or require Fourth Amendment protection. So you're looking at the totality of the government's actions and the broader picture that they create, and that's why it's sort of called a mosaic. So if you go back to the Jones case in which this whole theory was developed, so again, the vehicle location in each situation was not problematic. It was the overall image that was created by the activity of the GPS device. It was the overall, you could say, mosaic picture, how the picture was drawn, and how easily it was for technology to be a tool to draw that picture. That was a very important part of the decision, and one of the usually justices that you wouldn't normally quote in privacy cases, also he does have his moment. Justice Scalia of the United States Supreme Court says, well, it's like having a little police officer in the trunk and, watching you while you're driving away, and that's simply not something that we authorize as the United States Supreme Court. And so it's the mosaic that requires the court supervision. It's the mosaic that requires a warrant, even though you could technically argue that each little stone there wouldn't necessarily require a warrant, and each little stone wouldn't really be worrisome in terms of people's rights being infringed. That was a significant, I think, step for the United States Supreme Court, and has created a lot of theoretical interest, obviously, amongst privacy scholars. And the reason why it's significant is, again, because it allows for them to extend court supervision to situations in which normally the Fourth Amendment would not apply, so public spaces, this kind of collection of personal information. And it also allowed them to speak a little bit about the role of technology as facilitating this kind of collection of information. Of course, there's a big conversation that's part of that, which is the big data conversation that's happening not just in the United States, and really the ability to sort of not just collect all of this data, but make sense of it through some algorithms. And for those of you that were yesterday and heard the president of the ACLU speak at the IEEE conference, you heard that her concern is really, well, are there the algorithms that will make sense of all this data? And that's, I think, an important part. So that is, for me, the mosaic theory is the way into an understanding of the potentially bad side of drones. And let me sort of get there in stages. Here's a quote. I don't know if you know where that quote is from. Imagine that you would. Can I ask the 1984? And so I thought I would put it up there because it's so fitting to where we might be getting in 2014, which is 30 years down the line. And all of these eyes that are watching you, and here they are. Here's the mosaic drone. Right? This is an image from the US Argus imaging system. I'm sure those of you that know the technology are quite familiar with it. Argus stands for Autonomous Real-Time Ground Ubiquitous Surveillance. So I mean, the name just says it. Just says it all. And the question I think that we have to discuss today is how can the use of this or such devices be reconciled with some notion of liberty that we want to maintain? Is there, you ask from a theoretical, legal, privacy perspective, is there some kind of way to balance, the good uses that we've seen in the earlier session that will enable us to use drones in some way, together with the protection of human rights, or at the very least, liberty. So you folks probably know that originally we had hoped to also have Ontario's privacy commissioner here today, and she couldn't make it. But I think if she were here, she would probably say, or at least ask, is there a way to design such devices in a way that you can sort of design privacy or liberty into the way that they function? Because otherwise, she could be quite concerned about some other concerns that she had voiced in the by design, was the idea of surveillance by design. And that's where this potentially could be leading if that approach is unsuccessful. But I have a more fundamental problem. I don't even get yet to the stage that can we design some kind of privacy protections. My concern is at an earlier level, and the position I'm going to put to you today is that I probably think that despite all the good drones could achieve, we should not, as a society, engage in this exercise, and that we should have strict controls over how drones are used, if not really to perhaps ban certain uses outright. And I'm saying that, again, as I said, a bit to sort of have a conversation later on, but partially because I do worry, and Ian spoke a lot about the importance of regulations for safety. I'm not a person that has a lot of faith in regulations at the end of the day, and I worry about regulations, certainly privacy regulations. There's been in Canada, has been a very weak history of how privacy legislation and privacy regulations are actually used to protect the public interest. So I worry about that. Here are a couple of other examples in which I just quickly will go through before I talk about the balancing act, and just illustrate to you some other ways in which technology has really sort of moved ahead without a proper regulatory framework. This is in the area of smart meters and the smart grid. This is research that was done 30 years ago, I would say, or maybe 25 years ago, using a very primitive form of smart meters that were taking measurements, really an external device and the capability, the capacity of smart meters today far exceeds the ability of these devices in terms of analyzing what goes on inside the house. I don't know if you can see, but the analysis shows you when the fridge is open, when the toaster is on, the washing machine. So you start off with something that has a lot of good potentials, but it comes, again, as a way to circumvent the traditional constitutional protections or charter protections in Canada that you might have, because it's just now part of technology. In Ontario, the use of it was not even optional. We were mandated by the government to put smart meters on each and every home, which is a big issue if you're talking privacy protection and at least the ability to choose. Maybe I'd like to just pay more for my electricity but not be subjected to at least give me that kind of a choice. The point is that there has been a lot of work done on the regulation of these devices from a smart grid perspective, from an engineering perspective, from a safety perspective, from the resilience of the grid perspective, all of which are very, very important, all of which are very, very good, but we don't end up with sufficient privacy protection at the end of the day through the regulatory exercises that we engage with. And the two other recent examples, of course, you're familiar with this. I've been talking to some colleagues in the United States. They are leaning on the side that this is probably illegal in the United States right now in the sense that there is no legal framework that facilitates this kind of information flow from the private sector to the public sector. So this could be subject to a successful challenge, but this one, the Yes We Scan, the NSA side, the Verizon kind of approach, this actually has a more robust legal framework, a more robust regulatory, if you can believe it or not. There is the secret court, there is court supervision, there is all these things that have sort of been set up to protect, and yet we are very uneasy with what the sum of all of these regulations actually achieve in society. So I worry, I'm sort of throwing these up to say, you know, I worry about the power of regulation under the current system and whether we should be there or not. But let me talk about how I think we can use the existing tools, and I'll give the Canadian context to sort of try and figure out whether we can draw a balance between the good uses and the bad uses. I start with the Canadian charter and put up here the language of our charter, which is, as from I recall, if I read the Fourth Amendment, is different. And this is Andrew Clement's point. It doesn't really talk about, you know, a physical space that is a private space, but it talks about a right just to be secure against unreasonable searches and seizures. But like any right that we have in the Canadian Charter of Rights and Freedoms, it is also limited. And these are the limits, reasonable limits prescribed by law, demonstrably justified in a free democratic society. And that's sort of where the meat is. That's where the lawyers sort of go and try and figure out, well, let's take this kind of technology that is coming our way and figure out whether it meets this or not. So I was going to ask a few questions of people in the room at this stage. By show of hands. If I had clickers, I would ask you to do clickers. I just want to know how many believe, like after all is said and done, that the domestic use of drones by government is inevitable. If you just, yeah, so there's that. That's probably half the room for the people that don't see. And then I'd ask you the further question, how many of you believe this is in principle an infringement upon your liberty? So almost, yeah, I would say, yeah. Okay, so and then how many of you think that for government purposes I should have put there, will be effective, will be a good use if you want to take the sort of, let's say, right-wing, not citizen, but taxpayer perspective? How many of you just believe in the sort of, this is a good use of where my money is going in terms of, yeah, okay. All right, that's okay. So it's worth. It depends on its use. By government, I should say by government,
yeah,
right?
Even when the government uses it for
such a wide range. Fair enough. That's what we're going to talk over lunch. Yes, and then I guess I think the last one that I had. How many of you think that as the end result of the process, you will have a reasonable protection in terms of your freedoms after all of this with the regulatory process? I think maybe I've made you into skeptics at least a little bit. So this is really what in the Canadian context is called as the Oakes test, and some of you might be familiar with it. It's paraphrasing what the Oakes tests call, you know, how do we do a test to figure out whether what we are doing is placing these reasonable limits, placing these constraints that could be justified in a democracy on our rights and freedom. So it has to be, for the Oakes test language, it has to be sufficiently important, and there's an element there of proportionality. These are the two things that we always need to look at it. And so let's try and unpack drones in that case. What is sufficiently important, generally speaking, before we even get to drones? So we are talking about concerns that are pressing and substantial in a free, this is a quotation from the Oakes test, concerns that are pressing and substantial in a free and democratic society. So where do we draw the line? Is it national security? China is attacking us, for example, and we need to defend ourselves, or is it terrorism? We have terrorists running amok, in Canadian society, and we need to protect ourselves from them. Or is it speeding? Is speeding nationally pressing significant? We had a huge debate in Toronto a few years ago. The police services here were not able to get a helicopter for their, they have to borrow a chopper from some other luckier jurisdictions. I can see the chief of police coming to the city or to the board and saying, hey, you know what, I can get drones for how many? What's the cost for the? Okay, well that's great. That's not as expensive as a chopper, right? And I'll blanket the sky with them, right? And I'll use them to enforce traffic. That's wonderful. It's cheap, it saves me manpower, I don't have to spend police officers chasing, the image is captured, high resolution, I can show that, that's just terrific. So these are the questions I think that we need to be asking, because this is where we are going to go in terms of government use. It's not just going to be something that's hovering as an eye in the sky to capture the terrorists like we see going across the ocean in some other countries. So I really trying to steer away from those kind of conversations. But I think even in the Canadian context, we have to think about what are these pressing substantial concerns. And we haven't had that debate. And I'm hard-pressed to find in, let's say, a Canadian domestic context, those sufficiently pressing concerns, although we could talk about it. And then the second question is proportionality. Okay, proportionality. Whatever we're doing must be rationally connected to our objective. That's again from the Oakes test. And another quote is, it has to impair as little as possible the right of the freedom that has in question. And here's the third quotation. There has to be proportionality between the effects of the measure and the objective, which initially we said is of sufficient importance. So not only do we have an objective that is sufficiently important, let's say for the sake of the argument, I don't know what it is. I mean, for me, it's not speeding, maybe it's saving a human being's life. Perhaps that's important. We saw that example. I don't think anybody can sort of say that, it's not good to have a tool that can save somebody's life when they're stranded in the snow or in the storm or whatever, and we can actually use that. But we then have to say, well, is that proportional in terms of what we're going to be doing with the rest of society, right? What are the widespread effects beyond that one life that's being saved on society, beyond that objective which is sufficiently important? What does it create for the rest of society? And my concern and my fear is that the harm that is created is greater than the good by subjecting us to surveillance. And so we have to draw we have to look for proportionality for two things. First of all, if there is a rational connection, which I would say for drones, say, do drones work? Are they effective? And that's something that we really have to sort of figure out. And I think presentations like the videos that we've seen show that you can't really, I wouldn't really be trying to I couldn't probably mount a strong argument that drones don't work. I mean, I think unlike some other pieces of technology that we're not getting into today, like for example, body scanners at airport, you can have a very good conversation whether they work or not. But drones probably do a better job in terms of technology. But I think the important policy questions are, it's not for who decides this. It's part of the public conversation, and how do they make these decisions? So if we're told, for example, that we're just to worry on private sector commercial use, and then as Andrew has pointed out in the earlier conversation that we were having, we have jurisdiction in Canada to privacy commissioners. Privacy commissioners then step in and play a role. My fear is that they cannot play an effective role because they're quite limited in terms of their resources. So they have they have the jurisdiction over it, but they lack the capacity to really effectively carry out their role in the debate. And I think I heard Ian saying that, Transport Canada, they want to be focused just on the safety of it. And I think that's fair enough, right? They shouldn't be worrying about the privacy. We saw it with the smart grid as well. The engineers that are in charge of the Ontario Hydro, they don't want to be worried about the privacy. They want to make sure that they have an effective grid. It's very difficult to get that combination. Maybe through those educational programs, we will be able to build a generation of more ethical engineers that know enough to think about these issues, but they really are not going to be the experts that are going to have to sort of wade through the policy debates. That's where we need the resources on the part of the privacy commissioners, at least if we're talking commercial use on the hand of the privacy, and the resources are limited. And when it comes to drones, again, we have had non-existent public conversations in Canada. Really, there has been absolutely nothing. No government body, nobody has come and said, let's have a conversation. Let's see what the Canadian public wants to do about this. Let's see let's bring all the stakeholders together and let's listen to all the concerns and let's formulate some kind of policy out of all of that. That has simply not been taking place while people are going down to BMO Field. I mean, that's a hair-raising story, and just like flying their drones while the public sector sort of is twiddling their thumbs. So almost at lunch. Last point I wanted to say is about part of the Oak test is the point about minimal impairment. So if you are considering technology part of the proportionality, or I should say part of the reasonableness that the court is looking for, well, is this the least sort of damage that you can do by using this technology? And they're asking, well, is there no alternative, for example, to the use of drones? And here's a quotation from body scanners. You have to actually look for the things that are dangerous and not just scan everybody. This calls for a total change in approach to the issue. We heard the same concerns on the NSA program, right? Blanket surveillance with no effective algorithms, just going after everybody and not knowing or not being able to zero in on the issue. The same questions could be asked of drones, especially if drones are used by government, right? Are they the best way to sort of capture it? And perhaps they are, I don't know, but that's a conversation that you need to sort of go through and understand. I'm not convinced yet that they are in the hands of government the sort of the most minimal way to sort of achieve the goals that we want. And then we end up, I think, with really, I'll end up with this slide again, effects versus objective, and I'll say what it boils down, at least for me, is what is more harmful at the end. That's where we're sort of trying to balance it, and that's where I'm sort of leaning against drones for the moment, because I'm thinking, I put in one example, what is more harmful to society? The loss of life caused by terrorism, if you want to put it, that's one of the stated goals, for example, of government, to use any kind of, is that more harmful? And I put it to you, or you think about the person that is in the snow, and I'll say, what's more harmful? To have one person's life lost, if we're talking about a society, is that more harmful? Or is what is more harmful to our society, the change that our society has gone through in recent years, certainly let's say since 9/11. And although drones have been around for quite some time, you know that when you mention these places like Afghanistan and Iraq, you really sort of see the widespread use of drones by government for these purposes after 9/11. Do we want to end up in a society where, as you're saying, if you're down in the United States, you're just putting your own machine gun right on the drone, and that's going to be your security person hovering up from above protecting you? Or in Canada, perhaps you'll be concerned a little bit about the potential weaponization of drones once the infrastructure is already up there. And I know it's a little bit far-fetched, but I didn't believe that a mass-spread NSA surveillance system was also a logical, sort of rational outcome until we saw those leaks. So I think we are at a stage today that we have to really think not only about what we expect our government, and in Canada it's difficult because we have this basic faith in peace, order, and good government. We have to think a little bit outside of that envelope, and we have to sort of question whether our faith in good government and in good regulation is enduring, or are we setting up systems that could be misused down the line. And one of the things that worries me the most about drones is that they are a mobile platform that could be used not just for capturing images. Almost all of the videos that we have seen are talking about drones as, except for the pizza one, I think, are ones that talk about drones as a platform for a camera, for capturing an image. That in itself has surveillance implications, but what worries me is that this is just a mobile platform. And you can put a lot of things on a mobile platform, and we haven't had that conversation. We can look to other parts of the world to see what goes on these mobile platforms. And that concerns me, and I think we have to think about those in the Canadian context, even though we're thankful that we are living in a certain kind of model of a liberal democracy here, at least right now in the present time. It has to be part, I would say, of the conversation, and that is what worries me. So, sorry, I thought I took that off. I took the wrong slide off. I had a slide of a drone. Oh, sorry. I had a slide from another presentation there, but it was a very nice image of a drone in the sky. I know, it was for yesterday, but it slipped into this one. I think that drones failed to pass the test. I think that we need broad public consultation. I worry about private sector creep in what we call, the technology starting in the hands of the private sector with the best of intentions. We start up with things that we think are just wonderful, like a service like Facebook that is great for socializing, or a phone company that does it best to ensure coverage, and can you hear me now every step of the way, and we end up with the technology and the infrastructure that is set up by the private sector then used by the government. And so I think it's worthwhile having this conversation at the very early stage, both in terms of how people that have the best of intentions in the private sector are going to use it, and think about all the implications all the way down the line. So I thank you for being patient just before lunch. I think lunch is just on for right now, and as I understand it from the organizers, we're going to go into that room, have lunch for a bit, and then start the conversation. Is that the plan? Okay, thank you very much.